Okay, you asked for it, so let's buckle up. Within the Internal Revenue Code, the term non-resident alien is a word of art. This term has a special use, different from what common sense and common logic dictates, just as the term employee in the Internal Revenue Code is a word of art, which means an elected or appointed official of the United States. See 26 U.S.C. 3401 C and 26 CFR 31.340 C. The terms alien and non-resident alien are also defined in the regulations at 26 CFR 1.441-1 C. Let's go deeper. A natural person who lives inside the 50 states of the Union, which is outside of the federal zone, can be a non-resident alien without being an alien, which at first glance would appear to be a contradiction. One would ask, how can a person be a non-resident alien without being an alien? The answer is easy, because a non-resident alien, as defined in 26 U.S.C. 7701 B1 B, all caps, is someone who is not a U.S. citizen or a resident, which is what a national but non-citizen is, as defined in 8 U.S.C. 1101 A 21 and 1101 A 22 B. That same national can't be an alien because aliens can't be citizens and nationals at the same time, according to 26 CFR 1.1441-1 C 3 I. The terms U.S. national and non-citizen U.S. nationals are equivalent and interchangeable. An examination of the IRS Form 1040-NR confirms the fact that U.S. nationals are indeed non-resident aliens. The federal government has tried to confuse private citizens so that they would discount being a private citizen. The term non-resident alien is a contradiction deliberately designed by lawyers to confuse us and to obscure the actual truth. All residents of the United States can only be aliens under the Internal Revenue Code. When we call someone a non-resident, we are saying he is not an alien. Non means not, am I correct? You see, if Congress were honest about the definitions they use, they would use the term non-resident national or foreign national instead of non-resident alien in 26 CFR 1.1441-1 C 3 I. And then they would have told us that this status under the Internal Revenue Code applies to people born in one of the states of the Union. If you like this so far, we'll come back with more. Let's continue our study course. A non-resident alien is non-resident to the United States as defined in the Internal Revenue Code at 26 U.S.C. 7701 A9 and A10, which simply means that he does not live in the District of Columbia, the federal United States, the federal zone for short. You see, there's no way to interpret the definition of the United States other than the meaning District of Columbia for the purposes of Subtitle A, Federal Income Tax. The Constitution and federal law both confine all persons holding public offices to reside in the District of Columbia. The United States Constitution, Article 1, Section 8, Clause 17. I quote, "All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except otherwise provided by law." End of quote. That's Title 4, Chapter 3, Section 72. A non-resident alien who does not hold a public office in the United States government is not responsible for income tax withholding under Subtitle C of the Internal Revenue Code or for federal income taxes under Subtitle A of the Internal Revenue Code. People not holding public office also cannot be levied upon under 26 U.S.C. 6331 A. All income not effectively connected with a trade or business in the United States or earned from labor outside of the federal zone of the federal United States is exempt from exclusion as gross income and exempt from withholding. You don't believe me? See 26 CFR 31.3401 A 6-1. A portion of the regulation I stated is confirmed by the statutory rules for computing taxable income found in 26 U.S.C. 861. Okay, listen to this. The United States includes no other places than the District of Columbia. Let me quote, a citizen of a possession of the United States, except in Puerto Rico and Guam, is treated as if he's a non-resident alien, an individual. See it for yourself in 26 CFR 1.931-1, status of citizens of the U.S. possessions. Here's another quote. An individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States within the meaning of the subparagraph A, see 26 U.S.C. 7701 B 1B, non-resident alien. You'll see it for yourself. You see, Americans born in the states of the Union, i.e., in the United States of America, and domiciled there, are not citizens of the United States under the Internal Revenue Code or any federal law of the United States.
Did you know that all courts in the United States of America is acting as a bank or has the capacity to act as a bank? Well, let's talk about it. Book reference. First, let's look up the definition of bank. A bench or seat. The bench of justice, the bench or tribunal occupied by the judges, the seat of judgment, a court. An institution of great value in the commercial world empowered to receive deposits of money. Now let's stop at that part. So let's focus on two things that was mentioned there. One being the great value in the commercial world, and the second one is receiving deposits of money. So let's check this out. Let's go to Title 28 United States Code, dealing with the Judiciary and Judicial Procedure, Part 5 Procedure, Chapter 129, Monies Paid into Court, aka a deposit. And look at everything mentioned here. You have a section dealing with deposits of money in pending or adjudicated cases, a section for withdrawals, a section for deposits of other money, a section for payment of fine with bond money. That's very interesting. And you have the investment of court registry funds. So all these are functionalities of a typical bank, and it further substantiates that courts are actually banks or have the capacity to operate as a bank. Now from there, let's go to the court side and talk about appearances. Because in court, there are general appearances and special appearances. But don't take my word for it. Let's go to the law and see what the law has to say. Book reference. General or special appearance. A general appearance is one whereby the party appears and submits to the court's jurisdiction for all purposes, while a special appearance is made for the sole purpose of questioning the court's jurisdiction. A special appearance is one whose sole purpose is to question the jurisdiction of the court. A further or later request for other relief may be a general appearance or constitute a waiver of the special appearance. A special appearance is a proper way to challenge subject matter jurisdiction. So how does that tie into the fact that court act as banks? Well, check this out. Well, in banks, particularly with reference to monies, deposits are classified as general or special. Do you think that's a coincidence? Oh, before I go any further, you better share this out. A general deposit is where the money deposited is not itself to be returned. So like a general appearance, you're just submitting yourself to the jurisdiction. A special deposit is a deposit in which the identical thing deposited is to be returned to the depositor. And a special deposit, much like a special appearance, is for a specific purpose. But let's do a little history to see where all this stems from. Civil law, and Roman civil law are convertible phrases meaning the same system of jurisprudence. So let's look at some Roman history. Book reference. Under the chapter Roman law, the law of procedure, each party deposited with the magistrate a sum of money, which was forfeited by the losing party to the state religion. The defendant also had to give bail, which is a bond, as security for his subsequent appearances. The magistrate then turned over the dispute to a person on the list of those qualified to act as judges. If the defendant lost his property, sometimes his person could be seized by the plaintiff until the judgment was satisfied. And that also shows how law and history go together and proves that courts are acting as banks, and on a deeper level is legal human trafficking. Share this out to help spread the knowledge.
What's up, everybody? So I'm going to tell you a little story, and that story I hope you like and you share, because this is true. So I'm going to answer your questions why you have no rights, and I'm going to tell you why you're being crapped all over. And I suggest you share this video as fast as you can before they take it down. The reason that you don't have any rights is because you don't have any common law courts in the United States. Well, you have one, and you don't know where it is. And all the attorneys and all the judges are against you. Your entire system knows that you're not smart enough to exercise your rights. So I'm going to tell you where to go, and I'm going to tell you what to do. If you've been crapped on by a judge, or you've been crapped on by a government officer or agent, you need to go to the United States Court of Federal Claims, which is 3 buildings in front of the White House on the right-hand side, and it's the red building. In 1854, the Whig Party had died, and the Republican-Democrat Party split into 2. It's one party working together. It's all a facade. Lincoln and his boys took over the government, and President Franklin Pierce knew it, and so did the legislatures. So they passed the United States Court of Federal Claims, a court of law and fact for citizens when the government does them wrong. If you've been wronged by a judge, and this includes Donald Trump, I'm independent, I don't really care who the president is because it's all a joke. The reason you're not getting any answers is because your stupid attorneys are taking you to the wrong place. That's right. They're either stupid or they're lying to you because they're all working together. If you want to punish a judge, there's only 3 United States courts in the world. And guess what? They moved them all off of the shores of the United States. They're called territory courts. One is in the Mariana Islands, one is in Guam, and one is in the United States Virgin Islands. You don't have any rights because you don't have any courts. And judges are out of control because you don't have any place to punish them. I suggest you share this as fast as you can before they take it down. These are the facts. The United States Courts of Federal Claims will get you a declaratory judgment of fact and law. The territory court in Guam and the Mariana Islands and the U.S. Virgin Islands will get you to punish judges. Good luck. Have fun. Go get them.
Chapter 16, the causes of illness. Are they edible? Are they like chickens and cows and fruits?
None of the animals are used for food. Some of the plants are edible. All the prototype plants used for food are called the trees of life. They are used by the leaders to prolong their lives beyond the normal 7,000-year lifespan. The elders live for over 700,000 years using the trees of life as nourishment.
Can anyone really live that long?
Believe it. You'll soon witness it.
What causes sickness? Are there separate causes for every illness, or is there one genetic reason why people become ill?
This may sound strange to most people, but among the people of the Black nation in their natural environment, there is no sickness. Sickness did not exist before 6,000 years ago and will cease to exist after the end of this cycle. All sickness is caused by neglecting some aspect of your character. That will sound even stranger to all modern people who have been raised and educated to believe in the physical causes of illness alone. Every illness is related to some aspect of your character. The body is the unity of all aspects of character, and neglecting one or more of them results in illness in the corresponding part of the body. Among our people in our natural environment, there is no neglecting of any part of our character. We also know the proper foods to eat and the right time to eat them, so sickness does not have the slightest chance to exist.
Even the common cold?
Even the common cold. Isn't it obvious that the common cold is caused by stress? When the weather changes, especially from one season to the next, it exerts an external stress on the body. If the body is already under the internal stress of modern life, then you easily become prey to viruses. If you could remove all internal stress, thereby restoring that aspect of your character, external stresses would have no effect on you.
It's almost impossible to remove internal stress. There's so much pressure in everyday modern life.
Yes, this is the time for such things. It wasn't always this way, nor will it remain like this for much longer.
I know you said to keep the questions to the present subject, but you've mentioned the cycles before. Can I ask you more about that?
We'll have enough time to discuss all the details concerning cycles, but first things first.
So all the people were taught about the aspects of character and how to stay healthy?
Yes. There are 10 festivals that we call life rituals. During each one, the people are taught about the aspects. The character of every individual develops in a timely manner starting from childhood. The first 7,000 aspects of character are taught to children from the age of 7 until they are 14 years old. The school system is set up such that they attend the rituals 3 or 4 times a week for about 7 months of every year. The attendance is not continuous, naturally. They break during the planting and harvesting seasons and at the other times. As I already mentioned, the ancient calendar division had a week of 10 days, making 3 weeks to every month. The 12 months have 30 days each, with 5 or 6 days added at the end of the year, depending on whether it's a regular or leap year. This calendar is exactly as our ancestors, the ancient Egyptians, recorded it in their writings. They kept that system well until about 2,000 years ago.
I heard Dr. Jewel Pookrum reveal in one of her lectures similar ideas about the real nature of illness, the body, and the spirit. For example, she shared that often women who are knock-kneed have suffered some sort of sexual abuse. As a result, and a protective mechanism, the knees instinctively turned in to prevent further violation. Can you elaborate by sharing some specific illnesses and the character flaws or deficiencies to which they relate? I think sharing that information will help us who've been disconnected from the ritual process. Thanks.
Diseases fall under 2 classes of causes: those caused by a deficiency in the individual's own character, and those imposed on them due to a deficiency in someone else's character. The example you gave falls under the second class, where the deformity is not the result of a particular deficiency in that individual, but a character flaw in another person, who then imposes it on her by committing a crime against her. There are many examples of this type of imposition, some due to neglect, some unintended, resulting in deformities, traumas, addictions, and diseases. One common example is improper or inadequate breastfeeding. A lot of mothers in modern society breastfeed their children very inadequately, if at all. Once a child has had mother's milk directly from her breast, there is no substitute that can take its place, but many women are advised to feed artificial formulas to their children. The most common damage that results from this comes in adulthood in the form of cigarette addiction. Unbelievable as it may sound, a large percentage of addiction to cigarettes is the result of insufficient time spent at the mother's breast. Cigarette companies know this and design cigarette butts the same color as a white woman's nipple and make the rest of it white like milk to evoke these childhood memories, not to mention the chemicals they add to make sure people stay addicted. Other drug addictions are caused by insufficient love given to infants who need it the most. Later in adulthood, after experiencing the high of drugs, it reminds them of the parental love that they experienced but a few times and have been yearning for ever since. After the first high, they seek in vain to recapture that feeling and thus become addicted. All such ignorant impositions can be removed easily by training all people from childhood to develop their character properly. Such training would result in proper ways of raising children. At present, this ignorance is passed from generation to generation. Adding to that are the diseases that come from the person's own character deficiencies. These are caused mostly by lack of character development or improper development as a child. The biggest of these is the non-development of the natural courage in children. So many children are raised in conditions of fear. They are taught to fear strangers, to fear their own parents, to fear the dark, and even their own fantasies that come from their imaginations. This instilling of fear destroys their natural fearlessness and courage that all children are born with. The fear then later on causes many diseases, such as asthma and allergies. Neglecting to develop self-love in children warps their character the most and results in a myriad of diseases such as diabetes, obesity, and so on. As we continue with biology and genetics, I'll give more examples of other diseases and the character flaws that cause them.
Can you provide more information about the science of food energy? Do foods have feminine and masculine energies? If so, how does this impact our individual health? And how can you tell what energy exists around specific food?
Rather than female and male, food energies would more appropriately be called positive, negative, and neutral. Even these words give a false meaning. More accurate words would be energizing, harmonizing, and neutral, or stabilizing. There are foods to be eaten when people are low in energy, and they're opposite to be eaten when they're hyperactive. These harmonize the energy back into balance. In addition, there's a third type of food in the middle, so to speak. They're called staple foods, such as grains, and keep the energy more or less steady. Human beings are vegetarians under natural circumstances. At present, our bodies are in a less than natural state, so the eating of foods like cow milk is necessary, as well as a little meat, but much less than people usually consume. There are enough proteins in plant foods to nourish even the most active people, so it's possible to live completely without meat, as long as one takes a little milk. Plant foods can thus be divided into these 3 classes. They correspond to the 3 divisions of the human body: the head area, the chest area, and the intestinal area and lower body. The plant has a correspondence to these 3 parts in an exactly upside-down way. In other words, the roots of plants correspond to the head area. Foods like carrots and other edible roots nourish the brain and the head area. Not potatoes, though, which are not roots, but stems. Their roots are little hairs coming out of the tuber, so tubers are not root foods. Edible roots are thus positive or energizing foods. The stems of plants, which include grains like wheat and beans, are chest foods and nourish the middle part of the body. These are neutral or staple foods. The third group are those that grow at the highest parts of the plant, meaning the leaves and fruits. They harmonize the body's energy level. Although both men and women need all 3 kinds of food, women need the higher parts more, corresponding to the lower and middle body, and men need the lower part of the plant more, corresponding to the upper chest and head area. As far as specific foods to eat and how often to eat them, it would take too long to list. Besides, an accurate book has already been written on nutrition. It's a little book you can read in a day or 2 and has no equal as far as the teachings on nutrition and proper eating habits. It's called How to Eat to Live, Part 1 and 2 by Elijah Muhammad.
What's your take on the tidal waves that have recently hit the area around Southern Asia, areas filled with Black people? I remember hearing a tape by Dr. Delbert Blair where he alluded to such quote unquote weather occurrences as being man-made, specifically created to assist in wiping out Black people. What say you? My thought exactly. After reading about the incident, I thought the same thing. I believe that Whitey possesses the power, with the help of technology that is, to manipulate the weather and cause the earth to tremble. I knew this ever since I was a child. I remember that every time they tried to go up in space, there was a tremendous change in the weather. It would rain for days, and I would think to myself that they were interfering with Mother Nature. I do believe that this was man-made to help wipe out the Black race. I am not an expert on this matter, but I do believe in my heart that they do have a hand in any and everything that is the opposite of life and anything that is good. This is just my opinion. Peace.
Sisters, man-made disasters are nothing compared to this. This was definitely a natural disaster. The earthquake bodily moved an entire island in a few dozen feet and had the power of over 2,000 nuclear bombs. It made a crack in the earth the length of California. These large-scale natural catastrophes began last year with the Iran earthquake. They're going to continue and increase in size and devastation. To that will be added an endless war that is going to be joined by many other nations, begun by the invasion of Iraq. Add to that worldwide pestilences. And the next 6 years are going to see a drastic reduction in the world population, never before seen in all of history.
I always like to discover the why of occurrences, Black roots. When I saw the clippings of many of the victims' surviving family members, I saw many Black faces, unless I saw wrong. If I'm not mistaken in my identification, what do you suppose the reason would be for destroying part of the 1,000,000,008 million? What are the implications for the remainder of us? Thanks again for the continued and darkening education. Peace. There was another diet-related question I meant to ask you. I hope I didn't forget or overlook any previous information you may have shared on the topic, but I'll inquire again. What's your take on the eating according to your blood type theory that's currently on the natural health scene? Is there any validity to this idea, or is it just another European fad?
Although the 100,000 plus dead from the tsunami is tragic, it's nonetheless a minuscule number compared to the millions who die daily on Earth, many of whom are Black. I have not yet posted anything to clarify what I meant by the secondary requirement for the ending of this cycle, i.e. the incarnation of the 1,000,000,008 I'll explain briefly what it means and hopefully go into more detail later. First, it does not mean that once all the gods are incarnated on Earth, Black people are never again going to die. That's simply given the bodies that we live in the present. It will be so only after all Black people have had original long-lived bodies, when we will live continuously for 7,000 years. What it means is this: all the 1,000,008,000,000 gods have agreed to join in Yakub's project.
For all the state nationals out there, people corrected their status, I want to show you one of our documents called the Challenge and Rebuttal to the 12 Presumptions of Law. Just going to flip over to the first page. Got to check it out. Okay, here we are. Now let's zoom in. I've corrected my status per U.S. Code title and section 1101A, 21, and 23. Right there. Once I realized the 14th Amendment citizen, the U.S. citizen, is considered a dead civil entity. See Congressional Record, June 13th, 1967. Here's number 9 down here. Check this one out. A for-profit incorporated Article 1 court does not operate according to any rule of law, but by presumption under color of law. Did you know that? Pretty wild, right? So for all the people out there asking, okay, once I become a state national, I got my do not detain passport, they just don't give me tickets anymore, and that's not true. Cops don't even want to scan it. They act like they don't know what to do with it. Even though if you think about it, the book, passport book, is for international travel. You cannot international travel with the ID. It has to be the book. Did you know that? So riddle me this. What's the ID for? It's for interstate travel, not leaving the country. It's actually for that, and they don't know how to do it. They're not trained. This is the problem. Everybody wants to know how to beat it. Process, it's all about the process. You could learn it. If you've learned this much to become a state national, you can do all this. This is easy. You may not know this part yet. Once you know how to write these documents, everything makes sense. Then you know how to write them for anything. From a conditional acceptance to anything and in between, they're all very similar. You just learn the structuring. Our documents are editable. So you literally just edit to your information. Then we have 2 types of instructions. What you see on the front here is like a color code set. We include the stamps that we use whenever we do stuff. We have ABCD instructions as well that go with it. And we put video instructions. So anybody can do it. I don't know. This is just as easy as it gets, guys. You got editable documents ready to go. You got these instructions which you print out and you can do simultaneously while looking at these. You can fill out your paperwork. The paperwork's already color coded, so it's easy to do. And then you have videos to watch to make sure you comprehend. Now that you comprehend, you can take action. If you do get pulled over where there is no victim, you can exercise your rights and be the change. Teach everybody you know, stand up for your right. Because I don't know if you know, they're already trying to like dim the sun. People are going to be like, hey guys, there's no light outside. I think it's time we stand up. No. Right now is the time to stand up, guys. If you want change, you literally have to be the change you want to see, and state nationals rock.
So whenever you're using your name with any creditor, you have to have some kind of power of attorney at the transaction, at the inception of the transaction. Because you got to remember, the system only deals with debtors and creditors. So in every transaction, you got two parties, the debtor and then you got the creditor. So if you're not the debtor, then you should be coming with a power of attorney. Why? Because the power of attorney creates the agency, or it deals with the relationship between you and the property that you're actually using, conveying, or pledging. All right? It's very important that you understand that if you go to a transaction and you enter that transaction in the name of your principal and you're not operating as the agent in use of that principal, then the other party that you contract with takes on the place of agency. They become the agent and you act as surety in reference to your legal identity, because the legal person is an entity. And if you don't come in as the agent over your own entity when you dealing with another third party, then the third party takes your place as agent, because there's always going to be a debtor and a creditor relationship in every transaction. Very important for you to remember. Okay? Now it says that, all right, so basically, in order for, let me explain something else before I continue. All right, so basically, like I said, if you don't go and enter the transaction as the agent in use of your name, then the other party becomes the agent by operation of law, because the person doesn't have an agent. So anytime you go and you do business, if you don't have a power of attorney to attach to the contract, then you're not the agent. Well, you are the agent generally, but you receive no compensation as surety. Because in order for you to be compensated, in order for you to get the benefits when you're using something other than yourself that you have a right to receive benefits from, it has to be evidence that how you're using the property. If the property is not being used, if you're not using it as a surety to it, then it should be evidence that you're using it as an agent to it. So that's why the power of attorney is so important. Now let's keep on. It says an agent means an attorney in fact, or other person designated to act for the principal in the agency. So an agent, all the agent is an attorney in fact, y'all. That's all the agent is. But the reason why you gotta have the power of attorney, because if the other party don't know about the fiduciary relationship.
D16, Mirison, California Stores, Incorporated, v. McColgan, 30. Avoidance of taxes is not a criminal offense. The Department of the Treasury IRS Man Book, or Shuttle Agents M4112. Tax avoidance distinguisher from evasion. Any attempt to reduce, avoid, minimize, or alleviate taxes by legitimate means is permissible unless not an evasion of legal responsibility to take what advantages may accrue from the choice of any particular form of organization permitted by law. Varigance. Moot. F. Hins. Company v. Burnham, 51 R 1372 154 A 909. Never in the history of America has the need for property and asset protection been greater. It is a stark reality in today's world that a sudden financial reversal, an unanticipated lawsuit, or the stroke of a bureaucrat's pen can, overnight, wipe out a lifetime of accumulated savings and assets. Regulatory assaults on probate property are at an all-time high. Under recently passed asset forfeiture laws, the government can seize probate property for minor third-party offenses of which the property owner may not even be aware. This can create costly legal expenses and tie up time in court, even if the owner is innocent. The Pure Trust organization is a powerful tool, which can be used to protect a citizen's property from the myriad of regulatory abuses imposed by the government as well as frivolous lawsuits also. In today's computed and technological supercommunication age, your privacy can be invaded with the stroke of a keyboard with a citizen social security number or federal ID hash. Personal information can easily be discovered that can fraudulently be used to abuse their credit and misappropriate their assets because the pure trust organization is lawfully established and bank accounts are opened in a fictitious name without a social security or federal identification number. Paper trails to the citizen are permanently severed. Most Americans do not realize that they have a choice of laws when conducting their personal and/or business affairs. Rarely do we hear about the legally recognized American common law. It's the people's laws, created by and for them. The common law existed long before statutory law and is as viable today as it was in the beginning of our country's history. Originally, the common law was created protect the rights and the property of the people against the abuses of the sovereign king. Unfortunately, today the common law trust is seldom utilized to protect the people's property against the abuses of our current government in America. People are sovereign and may choose to legally conduct their affairs outside of government regulation. Under the common law, statutory law is a creation of the government for the purposes or regulating, fining, and penalizing the people, although it is in the best self-interest of attorneys, CPAs, and the governmental legislatory trust, which are a creature dry and tax requiring line or high. Us is the most inhibiting for the citizen. Statutory trusts provide only limited protection for property and a truckload or paperwork, and taxes are time in prison. The statutory trust is referred to as a Rev Cable Living Trust or Grantor Trust, and is required to call a 1041 form every year, whereas the common law American is law based upon and principles of justice and reason. Under the common law, as long as citizens do not infringe upon the rights of others and keep all agreements entered into knowingly, intentionally, and voluntarily, they are absolutely free to legally conduct their lives and/or businesses in any manner they choose. Under the common law, an American citizen cannot be compelled to do anything against his or her consent. The common law trust, being a creature of our constitutional right to contract, has no government regulations, no tax liability, and is not legally required to file a tax return. To put it simply, the Internal Revenue Service and other agencies of the government have no jurisdiction over common law pure trust organizations. It is American free enterprise in its purest form. Financial planning for the future. The knowledgeable and wealthy have continued to use the pure trust throughout American history. When the original 13 colonies won their independence, the man who was reputed to be the richest in the nation, William Bingham, who also served as a senator from Pennsylvania in the Second United States Congress, started a pure contract trust for his estate, which, at one time, held over 2 million acres in Maine. After 160 years of operation, the trust was terminated in 1964 upon the sale of the last of the properties involved, and because the number of beneficiaries had grown to over 300. During the trust's existence, however, it was not affected by the death of its creator or by the death of generations of trustees. It never paid a cent in probate costs or estate death taxes. The Kennedy family is known to maintain a number of pure trusts, a process which was begun when Joseph Kennedy created a pure trust to own the Chicago Merchandise Mart, which was valued according to a Chicago Tribune article dated March 22, 1947, at some $30 million. William Waldorf Astor, saving his heirs millions of dollars in probate costs and estate taxes, created a $50 million trust estate. It is reported that when John D. Rockefeller died, he had over 250 pure trusts. Rumor has it that the number of Rockefeller pure trusts now tops the 2,000 mark. The billion-dollar-plus Mellon family, Mellon Bank, has extensively utilized a complex structure of pure trust organizations. The Dallas Morning News carefully researched the estate of Texas oil man H.L. Hunt, who died with less than $30,000 in total personal assets, automobiles valued at $21,250 plus $5,443 and deposit in his name in the bank. Yet, he passed complete control of an estate estimated at $2 to $5 billion to his son, Bunker Hunt, without estate taxes or probate costs through the use of pure trust organizations. Why are we not utilizing the successful history of the knowledgeable and wealthy? The leading reason people are missing out on the best in trust is because the majority have done nothing in preparing to leave assets to their children. Most people feel that they have plenty of time and will eventually do what needs to be done. There are those who believe a good will is all they need. Their lawyer friend has convinced them that a will is the best option. There is no law that states that an estate has to go through probate, but a will mandates probate. Years ago, knowing that there was no way to stop trust from being used, lawyers arranged the legal system to where, if you used a will, or made no provision for distribution of your estate, then the estate had to go through probate. Wills were then promoted and trusts were ignored until the last 10 years or so. Tax-free living. A family utilized a trust and transferred its assets, including house, car, and equipment used in the family business, a farm, to the trust. The family then entered into an employment contract with the trust, which required family members to live in their former house because their presence was required at all hours to manage the trust. The trust agreed to pay the family's living expenses, including lodging and food. The family took the payments tax-free because the arrangement benefited their employer, and the trust deducted its expenses. IRS ruling, the arrangement is proper even if it was adopted with the explicit intention of avoiding taxes. Source: Letter Ruling 9,134,002. Pure trust definitions. The corpus. The property held within the pure trust is called the corpus. One or more trustees manage the corpus for the benefit of an unlimited number of beneficiaries. Capital unit holders, the exchanger or settler. The pure trust is implemented after it has been signed and executed by all parties to the contract, and the exchanger, who is also called a settler, conveys property into it, creating the corpus of the trust in exchange for capital units. This constitutes a tax-free exchange. The exchanger can hold all capital units or divide them among beneficiaries of the exchanger's choice. The exchanger, settler, can be a beneficiary capital unit holder or only a capital unit holder. Beneficiaries capital unit holders. Capital units represent 100% of the rights to the proceeds and the rights to the benefits of the property held in the trust. This is called the beneficial interest. This means that although the exchanger no longer owns the property, he retains the benefits. For example, if a car is in the trust, the beneficiary can drive the car. If a house is in the trust, he can sign a lease agreement with the trust and continue to live in the house. If a business is operating as a pure trust organization, the Benelli Siri capital holders have the right to the profits and proceeds of the business, etc. Proceeds or thalers of trust are netted. ERS, a beneficiary capital unit To go to D. Introduction. Advantages of a pure trust. Knowledge is the power of the global community. For those who consider confidentiality vitally important, trusts offer privacy, protection, profit. A trust provides the first step toward total privacy. With the trust can conduct banking anywhere in the world. International banking provides the most ideal method for receiving profits, but only through a trust. What can this do for you? 1. Assets are protected 100%. The number one enemy in the world is litigation. 2. Protection from creditors. 3. Protection from liability suits. 4. Protection from malpractice suits. 5. Protection from employees. 6. Protection from personal bankruptcy. 7. Protection from excessive divorce settlements. 8. Avoids probate. 9. Avoids inheritance tax. 10. Avoids estate taxes. Pure trust organizations. 11. Avoids court actions. 12. Eliminates attorney fees. 13. Eliminates or reduces accountant fees. 14. Eliminates executor's fees. 15. Eliminates or reduces income taxes. 16. Frees tax dollars for capital appreciation. 17. Provides complete control over your assets through trustees. 18. No public record. 19. Ownership and title can be passed to heirs in complete secrecy. 20. Trust is perpetual. The trust lives on continuously. 21. Heirs cannot change, challenge, or contest any wishes at your passing on. 22. The trust is easy to maintain and very inexpensive. Principles of trust. The people perish for lack of knowledge. Hosea chapter 4 verse 6. No state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contract. The Constitution of the United States, Article 1, Section 10. The citizens of each state shall be entitled to all privileges and immunities of citizens in several states. 9. The Constitution of the United States, Article 4, Section 2, Clause 1. The properly structured pure trust organization provides the quickest and simplest legal road to freedom, creating the ultimate in tax immunity and ironclad asset protection. By transferring assets into properly structured and legally recognized pure trust organizations, you are able to maintain complete control of all the benefits of asset ownership without the inherent liabilities. Because the assets are held in trust, they cannot be liened, seized, or levied for the debts of the trustees or its beneficiaries. Further, the trustees and the beneficiaries are not liable for the debts of the pure trust. American citizens have the unlimited freedom to hold, transfer, sell, or dispose of their property in any manner. They desire. It is neither unethical nor unlawful to entail. Gently protect your family's property and your family to legally and intelligently preserve what you have worked a lifetime to obtain. Pure trust organizations have been utilized by wealthy, financially sophisticated Americans for hundreds of years. Transferring assets into a properly structured pure trust organization is as easy as transferring property to another person. Assets can be conveyed into a trust even if an erroneous notice of lien has been filed against the property. As confirmed by the Chief of Accounting of the IRS, a pure trust has no tax requirements. Therefore, there are no legal requirements for a pure trust organization to file a tax return. Since the business trust has its origin in the common law right of the parties to enter into contract, and does not spring from a franchise granted by the state, it has been held that the constitutional authority to levy excise upon commodities, income tax, a term including corporate franchises, does not empower the legislature to impose an excise privilege tax on business trusts. 266 Mass 590, 163 and 904, 63. ALR 192. The courts ruled that a pure trust is not illegal even if formed for the express purpose of reducing or avoiding taxes. 13 AM Jur 2nd 85. In Weeks v. Sibley DC 269 F. 155. Edwards v. Commissioner 400 T. F2D 578.582 10th Seer 1969. And Phillips v. Blatchford 187 Mass 510.
Your lawyer's secret oath? What was the effect and the significance of the Erie v. Tompkins case decision of 1938? The significance is that since the Erie decision, no cases are allowed to be cited that are prior to 1939. There can be no mixing of the old law with the new law. The lawyers, who are members of the American Bar Association, were and are currently under and controlled by the Lawyers Guild of Great Britain, created, formed, and implemented the new bankruptcy law. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. Since the Erie v. Tompkins case was decided, the practice of law in this country was never again to be the same. It has been reported source unknown to writer, that every lawyer in existence and every lawyer coming up has to take a secret oath to support the bankruptcy. This seems to make sense after you read about Mr. Sweet's case file disappearance discussed later in this report. There is more to it. Not only do they promise to support the bankruptcy, but the lawyers and judges also promise never to reveal who the true creditor party is in the bankruptcy proceedings. In court, there is never identification and appearance of the true character and principle of the proceedings. This is where you can get them for not making an appearance in court. If there is no appearance of the true party to the action, then there is no way the defendant is able to know the true nature and the cause of the action. You are never told the true nature and the cause of why you are in front of their court. The court is forbidden to tell you that information. That's why, if you question the true nature and cause, the judge will say, "It's not my job to tell you. You are not retaining me as an attorney and I can't give you legal advice from the bench. I suggest you hire a lawyer." The problem here is, if you hire a lawyer, who is pledged not to reveal the true nature and the cause, how will you ever find out the nature and the cause? You won't? Why? If the true nature and cause of the action against you is revealed, it will expose the real creditor from whom this action and cause came. In other words, they will have to name the true creditor. The true creditor will have to state the nature and the cause. The true creditor will have to say, "It's a bankruptcy proceeding." The true creditor would have to say, "I'm the creditor and he's the debtor." That declaration then opens the door for you to question, "Who the hell are you? How did you get attached to my back and by what vehicle did I promise to become a debtor to you?" In this country, the courts on every level from the justice of the peace level all the way up, even into the international law arena, called the World Court, are administrating the bankruptcy and are pledged not to reveal who the true creditors really are and how you personally became pledged as a party or participant to the corporate United States debt. What would really kill these people off would be to compel the international bankers to send a lawyer to the courtroom and present himself as the attorney for the true creditor, the international banksters, then have the attorney to put into the record the true nature and the cause of the proceedings against you on that particular day. The international banksters told these various countries that they were now in a state of bankruptcy. The countries had been taken over by the creditor bankers, and there was no choice but for all these participating countries to declare bankruptcy. If they didn't agree to declare bankruptcy, the banksters threatened to collapse the economies and thereby put the countries back into the depression like the one from which they were just emerging. The banksters made an offer they couldn't refuse. To review and elaborate, in 1930 there was a worldwide depression. The bankers said, "Look, you can do it either of two ways, the easy way or the hard way. You just accept the bankruptcy and we'll let you out of the depression. If you don't, you're on your own." So all the countries involved agreed, because they realized that the international banksters had them by the throat. The countries therefore agreed that over a period of several years they would pass statutes and legislation for the implantation of the bankruptcy in favor of the international banksters. Now, I would say that the key banksters were Rothschild and family and their agents by way of Rockefeller, by way of the Federal Reserve banksters, who were more specifically involved as key banksters and their agents, is pure conjure on my part, but it really doesn't matter at this point. The point is, there was an international bankruptcy and an international conspiracy to cover it up. There was a banking creditor who made the offer. The countries accepted the offer in order to enable the representative countries to continue without revolution and to allow the politicians to remain comfortably in place. Under a delusion of solvency, the countries were allowed to continue to operate as though they were solvent, while in fact, the representative countries were bankrupt. The snare the bankruptcy scheme was is an extremely clever and diabolical plan. How did they possibly pull this scheme off in the area of real estate? The bankers did it with real estate, the same way they did it in the area of federal income taxes. These foreign banksters simply and deceptively devised ways and means to con you into declaring yourself as a citizen or a resident of the corporate U.S. Remember, the corporate United States is bankrupt per agreement and public policy. After you have been tricked into claiming you are one of their corporate United States citizens, you are given a social security number which ties you to certain meager benefits and privileges. Then, the banksters con your employer to function as an unpaid tax collector to con you into filling out their W-4 intangible property gift forms and 1,840 voluntary agreements. These slick paper agreements establish your voluntary indebtedness to the bankster creditor. If at any time you decide to balk at this scheme, because you don't like it, the real creditor never has to make an appearance in court to list the true nature and cause of the actions which is being brought against you. You end up dealing with an agency. The agency can conveniently grant itself immunity from prosecution because all it is doing, without your knowledge, of course, is administrating the bankruptcy, which the government agreed per the Geneva meetings. The court system never lets you put the original creditor on the courtroom stand, so you can ask him how he got attached to your back. The system is set up in such a way that the true creditor is protected and never has to make an appearance and never has to answer any of your questions or produce documents. Therefore, the true creditor never has to produce the law that gives him the right to pledge you, your body and labor, into indebtedness bandage servitude. Why? Because the Geneva Agreement in 1930 was done by treaty. The bankruptcy was not done by legislation. The agreement came first, signed in secrecy. Then Congress began to pass legislation to fulfill the bankruptcy obligation required by the treaty. Legislation being passed by Congress was henceforth and is thereby bankruptcy legislation. When cases came before the courts could make decisions based on the new controlling law of bankruptcy. It had nothing to do with constitutional rights. Now, any case brought in is under the new bankruptcy law and is not considered as a true constitutional case. It is now a bankruptcy case as distinct from, but cleverly disguised as a constitutional case. The members of the Supreme Court, of course, realized what was happening to them in the system of law. The court was being asked to perform in a creditor-debtor bankrupt proceeding to the benefit of the bankster creditors. The members of the Supreme Court said, "No, we will not give you a bankrupt proceeding decision that you can then enforce against everybody. A decision not only affecting corporate Washington, D.C. but also having effect within the corporate state governments. This, by the way, is fraud. It wouldn't be fraud if the government of corporate Washington, D.C. and the government of the several corporate states declared bankruptcy, then let the people know about the bankruptcy notice. When I say corporate government, I don't mean you and me. You and I are not the corporate government. The corporate government is the corporate capital of the corporate state. The government is a neutral government zone known as the corporate capital of the corporate state. The government is where the corporate state is. It is corporate headquarters. Just like corporate Washington, D.C. is the seat of the corporate federal government, the capital of the corporate state is the seat of the corporate state government. If the recent case, he won his case. He went into court and defended his common law lien on his property so as to be compatible with statutory law. The judge said, "However, since you presented me with a lien on your property, I will stipulate that the county is the owner of your property with the provision that all liens be satisfied." Sweet was very happy about the judgment. Sweet doesn't care if the county is the owner of the property because the county can't take the property for the next 90 years. The county can't take the property away from him because of his common law lien on the property. Sweet is free to use it, rent it, whatever. If the county really wants the property, they have to satisfy the lien first. However, there is a problem regarding setting a precedent. Sweet went back a couple of weeks later and asked them to punch up his case number. Guess what? The case number had disappeared. The reason the case number disappeared is that after the judge ruled the county owned the property, subject to the lien, it became a case that goes against the corporate county bankruptcy public policy. Since Sweet placed a lien on his own property, he is the one who has to be paid off first, not the county. The county is now required to satisfy the lien before the county is allowed to take possession of the property. The property is probably not worth the price of the lien. This would not satisfy the true creditors, the international banksters. If the county pays Sweet off first, the city has to put on their records a $75,000 deficit. The true creditors wouldn't like that deficit. They certainly wouldn't like the fact that Sweet's clever maneuver had outfoxed the foxes. What if 100, 200, 1,000, or 10,000 people in your state would just put a common law lien on their property and then stop paying taxes? Then cited Sweet's case, it would set a precedent. Let the county have the property as long as the judge makes the judgment subject to existing liens. In this situation, the county would end up holding all this property but could have no use of it. No rent, no taxes, no permits, all deficient. The bankster creditors certainly don't like this scenario. The banksters don't want any cases administered except through the application of bankruptcy procedure. The banksters want your rights. privileges, and due process strictly administered by and through the corporate courts under their corporate public policy. International bankruptcy procedure. The international banksters and their unregistered foreign agents don't want any evidence on the record, showing how you can get out from under them. Any revenue collecting individual or agency such as the courts, judges, lawyers, law enforcement officers, and tax collectors who are attempting to take money from you as a private American must be registered as a foreign agent. If they are not duly registered and properly identified, they are involved in extortion treason against private Americans. How sweet it is. As part of Sweet's maneuver, he filled out a financing statement using the UCC-1 form, whereby he put his wife and himself as debtors and creditors. Now, the legal situation is switched. The UCC-1 financing record Sweet filed with the state shows Sweet and his wife as being the parties of interest recorded with the state rather than the presumption that the international banksters are the parties of interest. There is an office within each corporate state, Secretary of State, that handles the Uniform Commercial Code UCC-1 claim forms. Since Sweet is listed on corporate state records as debtor and the creditor on his own property, his property can't be put up in any way for collateral against any debts claimed by the banksters. The reason is that the international banksters and their flunky agents now cannot prove that Sweet's property is debt property of the bank or the corporate county. The property cannot be put up against any debt claims until it is not encumbered by Sweet's lien. Sweet's property is not free and clear of all liens. The result is that for all practical purposes, the property is now Sweet's, being unencumbered by any further demand for payment of taxes. Sweet has not paid property taxes for many years. Sweet is now his own creditor, and Sweet is his own debtor. Therefore, the international banksters along with the county corporate thieves are knocked out of the stealing process. How sweet it is. Congratulations to Mr. Sweet. You may want to do it the way Sweet did. If you own property, you will need to get your deed and a common law lien, then fill out a UCC-1 form, then file it with the Secretary of State. This seems to be the only way for you to get out from under being a debtor of these bastardly corporate foreign international banksters. The judges have to know what's going on. The only way this scheme can work is to have all the lawyers and judges pledge to uphold the corporate bankruptcy public policy. The banksters just can't allow lawyers in a legal system who refuse to uphold the bankster policy. These renegade lawyers would have to be quickly weeded out. They certainly have a neat little system going here in America, the land of the free and the home of the slave. Attention, law student, you said you wanted to be a lawyer. Well, I hope you're reading carefully, because here is the legal system you're headed to serve, and serve you will. You said you wanted to be a lawyer so you can find out what oath they're taking, in secret, behind closed doors in solemn preparation for the business of the court as judges and lawyers. Now, you know the oath. The oath is simply to uphold the bankruptcy. If you want to be a lawyer and want to make a living as a lawyer, I can tell you this. They will weed you out at the very beginning if you don't bring in your paperwork under the bankruptcy procedures. If you try to defend your clients and try to help your clients, they will get rid of you. They will pull your license. So you spent all that money and time going to school under the disguise of helping people and you're wasting your time. Without that license you can't go into a courtroom. I would think about this. Traffic citation regarding the UCC-1 form. You can also file it against your car. Wouldn't that be a kick in the tail if you went into court for a traffic citation where you had signed without prejudice UCC-1 207, and you had dishonored the traffic citation using the UCC in your procedure by having signed without prejudice and having gone home and sent in your dishonor of the presentment of the traffic citation. Now, let's say you are in front of the judge. The judge says, "What's this dishonor stuff all about?" The judge will not want any mention that the citation was issued under bankruptcy. He is afraid you'll mention the bankruptcy issue. The reason you dishonored the traffic citation is that it was issued to you under bankruptcy corporate public policy. He won't get into that. When you get before the judge, you just state you have removed yourself from the bankruptcy. Tell him your auto is no longer pledged for collateral against the debt. He'll say, "Oh yeah, what are you talking about?" That's when you hand him the UCC-1 form that you filed with the state. This UCC-1 form will show that you are the debtor and the creditor on your auto. Now what happens? The corporate county state can't collect on the traffic citation debt instrument. Why? Because, not that you're the creditor on the ticket. If they collect a $100 fine, they have to pay you the amount of the fine. Our sweet it is. You're the creditor, aren't you? People have done this. Of course. There is no record, no paper trail. In such cases it is not cited. The corporate banksters' agents, clerks, lawyers, judges etc. take the information out of the records as soon as you beat them at their own game. Here is what I think happens in these cases. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. The American Bar Association is not concerned primarily with what happens in any case on the local level. However, when a case leaves the local level, by that, I mean the state court, city court or the justice of the peace, or even the federal court, and goes to the appeals court, it would appear that the American Bar Association takes notice of the case. It would seem that the American Bar Association must have an agreement that any action brought on an appeal must be reviewed by the American Bar Association. If this is true, it would make sense. How else would the American Bar Association, a branch of the Lawyers Guild of Great Britain, which is the legal arm of the Rothschilds dynasty, be able to monitor and administrate the corporate bankruptcy? It would appear that the American Bar Association would be compelled to review all appeal cases and to make certain any case brought under common law or the constitutional law that would expose the bankruptcy would be immediately stamped on the back that this case is not to be cited or published. I believe that this is the stamp origin and purpose of the stamp message in such cases. The Justice Department may be able to do that in Washington, D.C. I can't see where any judge or lawyer could have the authority to stamp or label the case as one not to be cited for future cases. I think that is an official stamp from the American Bar Association. The bankruptcy accounting system now. Joe, law student, if you're still attending classes and you have a good professor, ask him her about just where the stamp comes from that you've seen on many cases. Just who put it on the paperwork and just who authorized the citation restriction. Just who is tampering with the law. There is one thing certain. The creditor and or his agents are watching these cases very carefully. The creditor and his agents must balance their books. When you think of the IRS, be aware that the IRS is an agent of the creditor, the corporate international banksters. This is just one of the banksters' stateside agencies. The General Accounting Office, GAO, is another agency they use for this country. This is where all the accounting goes to keep track of.
Just abolish the federal government, which is the Constitution for those that don't understand it.
With all due respect, all joking aside, America is a landmass, okay? The United States is a corporation. The corporation does not rule the landmass. The corporation is a corporation, just like Walmart, Ford, or AT&T. And if you don't believe that the United States is a corporation, then go to Title 28, USC 3002, Section 15, Clause A. It says, and I quote, the United States is a federal corporation. Okay? If you go to UCC, it's okay, I'm not good with the UCCs, but if you go to the Better Revised Statutes, NRS 205.4611, 4-611, UCC 4-611 says the same thing as NRS 205.4611. It's been the UCC has been codified into the Nevada Revised Statutes. Your state has the same thing. Every state in the union does. It's sort of like a prerequisite for commercialism. So anyway, the United States is not the Constitution. The government is not the Constitution. The Constitution is what we are supposed to hold our government to, and we have not been doing that. Our government has been out of whack since 1933 when Roosevelt sold us out. Okay? You want to check some facts? Check some facts. You better ask somebody. All right? Be well. All rights reserved. And void where prohibited by law.